the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
How do you plead in indictment 21 SC 177351? How do you plead to the charges of willful obstruction of a law enforcement officer by use of threats or violence, terroristic threats, interference with government property, battery, and possession of a firearm by a convicted felon?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 30 days from today to file an appeal?
Yes, ma'am.
And do you understand that you only have 4 years from today 4 years from today for a felony and 12 months from today for a misdemeanor to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Ms. Hernandez. Your Honor, had this case proceeded to trial, the state would have proven that on November the 9th, 2020, at 1085 Helcombe Bridge Road, that's in Fulton County, Georgia, Atlanta, officers responded to the location of Metro PCS in reference to a fight between customers. During the investigation, Your Honor, they learned that there were two customers that were in a dispute at that location. Mr. Hernandez inserted himself into that argument, at which point one of the men that was in an altercation or in a disagreement with another customer, Mr. Hernandez ended up punching in the face and punching multiple times in the face. He left the scene and went to a local gas station in the area. When police arrived, they did go to that gas station where they were able to apprehend Mr. Hernandez. He did have a bulge in his ankle area where they did find a gun. When he was placed in the car of threats were made to the officers when they were trying to detain him. And then when they placed him inside of the vehicle, he was trying to kick out the door. That's where the damages come from for the interference with government property, causing a dent into the door. Other than that, he was taken in without incident. The defendant is currently on active probation. He has 20 days left on his 17 SC 154893 case. And I believe Ms. Crawford will give you the rest of his history. Or she can't, I will.
Okay. Tell me why you're recommending MADRC.
Well, me and Mr. Franklin have talked a lot about the defendant's actions that day. Mr. Franklin can probably go into better detail than I can as far as the help that the defendant needs. But I was convinced from the information that Mr. Franklin shared with me and from talking to the people who was involved in this incident. This was an incident where the defendant didn't know anyone there. And so his actions were triggered by something else, leading to us thinking or believing that he needs help. So he has served, I believe, 212 days. I think I have
241 as of today.
41. So 212 since our conversation, but 241 as of today. And that's why I was in agreement to him getting some help and going ahead and serving the time he's already served. That's why I agreed to him getting help through MADRC.
Okay. I'm just looking at the 17 SC case. Okay. All right. Mr. Franklin.
Thank you, Judge. So to begin, I'm going to give you a bit of a background on Mr. Hernandez Velasquez. When he was 10 years old, he was unfortunate in that he lost his mother. After that point in time, with her being his primary caregiver, his sole caregiver, he was bounced around the system a bit. He grew up in foster homes and that kind of situation. And his experience was not a great one. So he never was able to, I guess, develop the kind of structure that a lot of us are fortunate to have, or even some other people who come through the system are able to kind of come out of it with. That, I think, contributed a great deal to the couple charges that you are aware of already on his criminal history. He has made some positive inroads in that, despite not having graduated high school, despite having dropped out in the ninth grade, he has developed a bunch of usable skills that I think would bode him well later on in life. He does have a pretty strong collection of friends who essentially substitute his family that I think will help him stay on the right path. He works in construction, he does roofing, he does cement work, he does flooring. And those friends that I mentioned earlier, they are his connection to being able to get that kind of work. He has a friend by the name of Brian, who I believe he should be able to stay with once he gets out, so he would have a level of stability. But most importantly, Judge, in my conversation with Mr. Hernandez Velasquez, what became apparent to me is that this certainly was an incident that was pushed along by his use of alcohol that day. And so anytime I know that, the incident that we're here for is because of substance usage, I always make it a point to have a conversation with my clients about whether or not it was just kind of, were you drunk that day, or is your alcohol abuse a habitual thing, especially when we are looking at somebody who is 22 years old and already has multiple felonies, right? He expressed to me that he didn't feel that he had an alcohol problem. But in my discussions with Ms. Hall, it didn't appear that there would be any other reason why we would kind of be at the point we are today. If it weren't for the alcohol use that day, and the MADRC came about as a negotiation that if he doesn't have a real alcohol addiction issue, he at least is getting the daily reporting attention of probation. And if he doesn't have an issue, he should breeze through MADRC. If he actually does have an issue and either he is just incorrect about that fact or not honest with himself about that fact, then MADRC is certainly more intensive than just asking for an evaluation through probation and then treatment as needed. So we want to be assertive about making sure that if there is a root issue, that there's an opportunity to have that addressed. It didn't appear to be serious enough for us to want to have to seek out drug court or a private type of program. I think that the time sitting still in Rice Street, we're almost at 8 months at this point. I think that it has done him a bit of good in terms of just being able to pause and put things on an evaluation from an adult standpoint. He certainly had been a juvenile before, of juvenile age rather, at the times that he had served time before. But the difference in a year or two, I think, not having to deal with school, I think that, he sees the world a bit differently and will continue to grow in the way that he sees the world and understanding his place in the world. And I just think that the package that we have together, have come up with, is the most beneficial for all parties involved, Mr. Hernandez Velasquez and society as a whole.
Got it. Okay. Mr. Hernandez, tell me again how old you are. I was jotting down that you got your GED while you were in custody, and I forgot to write down how old you are.
I'm 22 years old. Sir.
22. Okay. Ms. Crawford, are you with us today?
Good morning, Judge McBurney. Yes, I am.
Good morning. Can you tell me a little bit about Mr. Hernandez's criminal history, please?
Yes, he has a 17 SC case that's open with 20 days remaining on that case. And then he has a case from 2020. It was out of Washington County, entering vehicle. It's no longer open. It's a closed case.
Got it. Thank you.
You're welcome.
All right. Mr. Hernandez, is there anything you want to add? This is your plea and sentencing, not anyone else's. So it was real helpful to hear from Mr. Franklin about your background. Anything you want to add to the situation?
Yes, sir, I would.
Tell me.
Sir, I just want to begin by saying that, like Mr. Franklin said before, I have gone through a lot, sir, and I have made a lot of mistakes in the past, but I'm willing to learn from it and, start brand new if I'm able to, sir. And I would just, like a brand new start, sir, just show that I am a good person and that alcohol did get the best of me, sir, and I do want to do better in life, sir. And that's all.
So tell me what would be brand new about this start when you get out. What's going to be different?
Sir, when my friend get back to work and stop alcohol and just any of that, sir.
Okay. And where's the plan for where you would live?
In Roswell, Georgia.
Okay. With this guy Brian?
Yes, sir.
Okay. Do you have a specific address? Because probation's going to need to have an address for where you're going to be. You don't need to give it to me right now, but you know the specific address?
Yes, sir.
Okay. And when did you last talk to Brian?
Like 3 days ago, 2 days ago, sir.
Okay. So you've been in touch with him. It's not going to be a surprise that you knock on his door saying, hey, man, I'm here.
Oh, no, sir. No, sir.
And does Brian have a house or an apartment?
An apartment, sir. Does
he have room for you?
Yes, sir.
Who else is in the apartment besides Brian?
It's just him and his girlfriend.
Okay. You have any kids, Mr. Hernandez?
No, sir.
Do you have other family in the Atlanta area?
No, sir. Unfortunately, it's just me.
Okay. Where do you have brothers or sisters that are somewhere else?
Yes, sir.
Where are they?
My family's originally from Honduras, so I have a couple brothers and sisters over there, and I have a younger sister that's in Florida.
Okay. And who does she stay with?
My uncle and auntie.
All right. Tell me why you think your relationship with alcohol will be different now when you get out.
Truthfully, sir, that I feel like once I had got released from prison, sir, I had went to prison when I was 18. I had got out when I was 21, sir, and I felt like I didn't get to live my teenage life, and I just wanted to be around in the mix so much that I was just drinking. And now I don't feel like that. I don't feel like I needed to be around the in crowd and drink and just to be cool and just have a good time. I don't need that, sir.
Why were you in prison for 3 years?
Sir, I got violated from the Washington County case. I had got violated. They revocated my probation.
What did you do that caused them to revoke your probation?
I had caught charges in Fulton County in 2017. So they revocated 2 years, but I did a year in Fulton County.
So the Fulton charges, it looks like it was allegedly a gang case. Those charges caused Washington County to revoke some of your time?
Yes, sir. I was on, I had probation down there for Washington County.
Okay. What are your thoughts about MADRC versus having an evaluation and seeing what that person recommends?
I talked to Mr. Franklin about it a little bit, and it was something I was willing to do and participate in, sir. And I have no problem with it. I'm willing to give it a try and give it my all.
So that would mean that you'd have to get from Roswell down to basically downtown, the probation office where they run the MADRC classes. And some of it may be virtual still where you would be on a screen, but the part that's in person, you have to come downtown. How would you get from Roswell to downtown?
My friend Brian, he's been a long family friend. His mother knows my mother for a long time before she passed away. So he has a car, and if he wasn't able to, I'm pretty sure that I know the MARTA transportation system very well, sir. So that'd be no problem. Okay.
Well, I think I'm going to try the MADRC with you. I appreciate Mr. Franklin flagging that there's an intermediate step, which would be to get to the evaluation. It may be that you have gotten the better of your taste for alcohol. Don't know. It's not that alcohol is illegal. That's not the point. It's what you do when you have too much. And it sounds like in November of last year, you were pretty much off the chain. It's fortunate you didn't get more hurt with those officers trying to get you calm and et cetera. But MADRC might help you, since you've been in for a while, have a little structure. I will tell you that initially your life will be mostly MADRC. So if you were thinking day one, I'm going to be at the construction site working 10 hours a day, that won't work. But as you progress through MADRC and the fact that you already have your GED, you'll move through it pretty quickly. They shifted to being classes in the evening so you can work during the day. But you do need to understand that MADRC is a requirement. It's not an optional thing. You don't go because you feel like it. You don't show up some days and not the other days. If you are missing MADRC, there'll be an intervention. And ultimately, if the folks who run it decide that you're not taking it seriously, that may be a probation violation. And you've seen what can happen if you violate your probation. That didn't go real well for you. So I just need to make sure you understand that MADRC it's basically a set of courses that you'll be taking to help you with job skills and this and that, and in particular with making sure you don't relapse into abusing alcohol again.
Yes, sir.
Okay. Well, Mr. Hernandez, I find there's a factual basis for your plea. Did you know the two guys who were getting in this fight at Metro PCS?
No, sir.
Okay. Anyway, sounds like that day was a rough one for you. And again, we're fortunate that it ended as relatively peacefully as it did. I also find that your plea is knowing and voluntary. Knowing means that you've understood all the things we've talked about. Do you have any questions about anything?
No, sir.
All right. Voluntary means no one's forcing you to enter this plea, but you've decided after speaking with Mr. Franklin about it that that's the right way to move forward for you. Is that correct?
Yes, sir.
All right. Then I'm going to accept your plea. I'm sentencing you pursuant to what we call the Probation Options Management Act. And all that means, Mr. Hernandez, is that while you're on probation, which you will be for a few years, if you have a technical violation, like let's say you miss a couple days at MADRC, you don't have to come see me right away. You and probation will work that out. But I'll tell you, if you get arrested again for something, or you get kicked out of MADRC, that's the kind of thing that comes back to me, and you and a lawyer and I and a prosecutor will figure out what the next steps are. Okay?
Yes, sir.
Mr. Franklin, Ms. Hall may have asked this and I missed it. We're working off a copy of the indictment. Do you waive any issues proceeding with a copy of the indictment?
Yes, Your Honor.
All right. Mr. Hernandez, I'm going to sentence you on count one of the indictment, if I get it back up on the screen here, to a term of 5 years to serve 7 months with the balance probated. Count 6 is a misdemeanor. I'm sentencing you to 7 months to serve on that. All these counts run concurrently or at the same time with each other. Count 7 is 5 years to serve 7 months. Balance probated. 8 is serve 7 months. And 9 is 5 years to serve 7 months. So the total sentence is 7 months in custody, but you'll get credit from the day of your arrest, which sounds like was November 9th, 2020. And then the rest will be probation. We're going to need to get some information from you in a minute about where you're going to be, your need to report to probation. I'd like to first resolve the 17 SC case. Mr. Franklin, my thought would be to revoke the balance and close out the case, but give Mr. Hernandez credit for the time he's been in. So that would effectively close 17 SC. 154893. Do you waive any due process notice rights that Mr. Hernandez has in connection with a revocation in that case?
Yes, Your Honor.
All right. So, Mr. Hernandez, we're closing out the 17 SC case. You'll be on probation just in one case, this new case involving what happened on the November 9th of last year. it will be a special condition of your probation, Mr. Hernandez, that you enter into and complete the Metro Atlanta Day Reporting Center program and its aftercare. When they're done, they don't just shove you out the door and say good luck, but there's some check-in afterwards to make sure you're doing okay. So you'll need to get through that whole program. That's your main project. You take care of that and work on the side as best you can. And you ought to be, like you said, in a new place. Maybe not running with the same guys you were running with before all this went down. You're still very young, but you have been through a whole lot in your 22 short years, losing your mom, in and out of foster homes, and then spending a lot of time in prison. I hope you are ready for a new chapter and want to try out a different way of doing things. We'll handle it either way. You know, if probation doesn't go well, we'll get back together and figure something out. But I hope for your sake that it does. Ms. Hall, did you have any other conditions you wanted to see on the probation?
No, Your Honor.
Okay, you can't really do restitution to the government. So if the car was damaged, the car was damaged, but can't do anything with that. I think that's it. Mr. Hernandez, if you were here in court, you would sign your indictment. You can't because you're not here. Do you authorize me to sign the indictment for you, indicating your guilty plea?
Yes, sir.
Mr. Franklin?
Yes, Your Honor.
And Ms. Hall?
Yes, Your Honor.
Great. I'll take care of that, and we'll get the no pros stamp on the indictment as well, taking care of counts 2 through 5. I don't have anything else other than that, Mr. Hernandez, we're going to need to get some address and contact information from you, and Ms. Crawford, who is with probation, will let you know when you need to report and where you need to go. Have you ever been to the probation office in Atlanta?
No, sir.
Okay, well, we'll get that to you, and Mr. Franklin may be able to get you some paperwork as well. I don't know how we'll get that, but you're going to need to make sure you show up there. Ms. Crawford, are you ready?
Yes, Judge. Mr. Hernandez, you're going to need to report to probation. The address is 276 Memorial Drive. I don't know if somebody there can write it down for you, but the address is 276 Memorial Drive, Southwest Atlanta, Georgia, 30303. Your report date will be Tuesday, July the 27th at 10 a.m.
Yes, ma'am.
And also, do you have an address or a contact person, name and telephone number I can get for you?
Oh, yes, ma'am.
Okay, go ahead with the information.
Do you want the phone number or the address first, ma'am?
Give me the person's name and then their telephone number, and then we'll get the address.
Brian Vasquez with a V, Vasquez with a V. His phone number is 470-430-2625.
Okay. And you can go ahead with the address.
1307 Grand, GRAN, Court Lane, Roswell, Georgia, 30076.
And you said that's in Roswell?
Yes, ma'am.
Was that an apartment number?
Okay.
1307, sir.
So, Mr. Hernandez, the tricky part for you is going to be remembering to get to your probation appointment, because if you miss that, they issue a warrant. It's a no-show. We don't know where this guy is, et cetera. If you have a way of contacting Mr. Franklin, he may be able to relay that information to you again so you can write it down. Because I know right now you don't have a way to write anything down. So you just need to be remembering, hey, I've got a probation date. You may have memorized it. You've got a better memory than I do. But if you need those details again, contact Mr. Franklin. He'll give them to you, and you can plug them in somewhere safe, because that's a pretty important appointment for you.
Yes, sir.
All right. I think that is it. Good luck, Mr. Hernandez.
Thank you so much, Your Honor.
All right. We're going to go to 4 North now for Mr. Bush. Mr. Bush, can you hear me?
Yes, Your Honor.
There he is. Good morning, sir.
Good morning, sir.
Mr. Bush, I'm going to let Mr. Franklin speak on your behalf. I'm not pretending to do that, but I want to let you know where I think we are with your cases. I think you've got two cases. You got one with some more serious charges, and then the one I'm more familiar with, where we had the suppression hearing where you were running from that officer and supposedly threw down a gun and things like that. It has been relayed to me that you are very close to resolving your cases with a plea, but that we are not quite there. And the prosecutor, Ms. Hall, had asked for a little more time so she can get the green light from her supervisor to move forward with what I understand to be. I don't have the terms of it. I don't need the terms of it, but I believe she and Mr. Franklin have resolved something. I assume that has had your input in it. But we're not able to do that today. That was the plan. We put you on the calendar today to actually lock in that plea. But it has nothing to do with Mr. Franklin. He negotiated hard on your behalf, and Ms. Hall has been doing the work she needs to do. She just hasn't been able to connect yet with her supervisor. And given how serious that one charge is in your older case, I think you can understand why she needs to get supervisor approval to maybe have that charge go away, which was relayed to me as, I think, part of the negotiations. So I want to share that with you. We're not playing games by making you show up in the booth and then we don't do anything. The plan was to sort things out today, but events are a little beyond our control. Mr. Franklin, is there anything you want to add to that?
Just to add a bit more context and texture to it. Mr. Bush, I came and we talked about initially what the range of potential sentencing could be. And then we had an opportunity. I told you I talked to the DA about it, and we got to a number that I asked if you were comfortable with, and you took some time and we talked about what that number was. There was one part of it that I guess myself and Ms. Hall talked past one another. We needed to have one of the charges dismissed. And we thought it was going to be able to get done by today, and it just circumstances didn't allow that part to get done. But I thought making sure that it got done was worth us waiting a couple more weeks, as opposed to us attempting a non-negotiated plea today. So the same offer I expect to still be in place a couple of weeks from now. We just did get the final sign off on it from one of the prosecutor's supervisors. Okay.
Yes, sir.
Do you understand all the way? Or do you need me to come kind of talk to you in person to make sure that you definitely understand everything?
I understand well, sir.
Okay. Well, I'll see you when I see you, and I'll let you know the next time we're supposed to be in court. Okay.
All right. Thank you, sir.
You're welcome.
Before you go, Mr. Bush, I got to ask two questions of the lawyers, and then I'll see if there's anything you want to ask about Mr. Bush. Mr. Franklin, will you be maintaining this case until it's resolved?
Yeah, if for some reason it goes to trial,
well, short of trial, if it's going to be a plea.
If it's a plea, then I'll come back for the plea. Yes, sir.
Okay. So Ms. Nelson will either try to remember to keep you in the loop, or Ms. Patel can let you know what's going on.
Absolutely.
Okay. Ms. Hall, did you have anything you wanted to add in connection with Mr. Bush's cases?
Nothing further, Your Honor.
On the calendar are both his cases. That was going to be my question. So whatever you and Mr. Franklin have been trying to work through would resolve both his cases?
Both his cases and his open revocation case.
Oh, three things. Okay, great. Mr. Bush, do you have any questions sort of procedurally about what's going on, or did Mr. Franklin make it clear for you?
Mr. Franklin made it clear for me, sir.
All right, then we'll see you in a few weeks, perhaps, to see if there is a plea in your cases. And if for some reason that doesn't go through, you don't like the sentence I impose, then we'll make sure we get you into court for a trial. Thank you.
Thank you.
We're going to position number 3 next.
Thank you. Oh, it's right there. And you are, sir, Mr. McAllister.
Yes, sir.
Good morning. I'm Judge McBurney. Mr. McAllister, you are on our calendar for what we call plea and arraignment. You've got some new charges here in Fulton County, and we need to figure out from your lawyer what the plan is moving forward. The lawyer is listed as Mr. Merrill, but Ms. Patel's standing up here in court.
Correct.
Is this going to be your case, Ms. Patel?
Yes, Your Honor.
Great.
And today we are waiving arraignment. I have that waiver ready. I did file a bond motion. We are not going to have it heard today. We are waiting to secure some housing, which I discussed with Mr. McAllister.
Okay. So, Mr. McAllister, Ms. Patel is going to give me a form that will get filed that gets things rolling on your case. Is this, Ms. Hall, your case or someone from one of the units?
It's my case, Your Honor. 88 Asia Besa.
Hey, how are you? Welcome back.
Thank you. I got back yesterday, so
Great
I'll be
to see
taking
you.
over all the DV cases now.
Fantastic. All well with you?
Yes.
Good. Well, welcome back. So, Ms. Beza, you're handling Mr. McAllister's case. You'll get discovery to Ms. Patel. And Ms. Patel, you will let Ms. Nelson know when we ought to set this down for a bond hearing for Mr. McAllister, such that you'll be in a position to say, here's a place he could stay.
Yes, Your Honor.
That makes sense. Mr. McAllister, do you have any questions about what we just talked about?
No, man. No, sir. We went over it yesterday, and she explained everything to me, what was going on. And
Great.
I know my situation, so I'm good with everything.
Excellent. Well, we'll see you soon to talk about bond. Ms. Patel will start getting discovery in the case, so she'll be connecting with you also soon to share with you what the case file says and what that may mean for how you might work the case out. But I think that's it. Ms. Beza, anything else in Mr. McAllister's case?
No, Your Honor. Ms. Patel and I spoke yesterday.
Great. Thank you. All right. Thanks, Ms. Patel. It looks like we're going to go to Mr. Johnson, position 4 next. Let me turn that booth on. He's not in 3 South. Mr. Johnson must be somewhere else because 3 South is good.
No, sir, I'm right here.
Oh, he's right there. Okay, great. You're just not in the booth. Any reason you're not in the booth?
He's in a wheelchair.
Yes, sir, I'm in a wheelchair.
Well, that would be a good reason not to be in the booth. Mr. Johnson, I'm Judge McBurney. It's nice to meet you. We had you here today for plea and arraignment. You've been indicted for aggravated assault and theft. Ms. Patel is here in court. You may be able to see her on the screen. She's going to let me know what the plan is from your side. And Ms. Beza, is this a case of yours as well?
Yes, this is my case as well, and I'll be standing on this one.
Great. You are coming back busy. Ms. Patel, what are we doing in Mr. Johnson's case?
Your Honor, today we'll be waiving arraignment. I did file a bond motion on this case that I would like to have heard today, and I spoke with Ms. Beza about that yesterday and let Ms. Nelson know as well.
Okay. Ms. Beza, are you comfortable?
Ms. Nelson, no, I should clarify.
Okay. Ms. Beza, are you comfortable talking about bond today?
Yes.
Okay. So, Mr. Johnson, 2 things. First, Ms. Patel's waiving arraignment on your behalf, and that just means we don't read the indictment out loud. Ms. Patel, will start getting discovery from the prosecutor, and then she'll be coordinating with you so you can see the discovery as well, so you know what the evidence is that the state thinks they have that would prove up these charges. Second thing, we're going to talk about bond. So I'm going to hear in a moment from Ms. Patel. I may hear a little from you. I may have some questions for you. And I'll definitely hear from Ms. Beza as well. And then I'll let you know whether I'm comfortable setting a bond, and if so, what the terms of that bond will be. Okay?
Yes, sir.
All right, Ms. Patel.
Thank you, Your Honor. Before you is Mr. Johnson. He's 51 years old. He's a lifelong Atlanta resident. Should he be released on bond, he would be living with a friend of his, Ralph Dexter, who lives at 6101 King Mountain Court, Atlanta, Georgia. Your Honor, my client vehemently denies the charges against him. As you can see, he has a number of health conditions. Essentially, he had a spinal cord injury that anytime he falls continues to be exacerbated, which is why he's in a wheelchair right now. While he's been incarcerated, he has had issues being adequately accommodated. At one point, they did not believe that the wheelchair was appropriate for him, and he was without one.
How long has Mr. Johnson been in custody?
He's been in custody since February 4th, 2021. He was brought over from New York, so I believe he spent some time in New York for a month before being brought to.
He was arrested in New York and
Correct.
extradited down here.
Correct. He was arrested on a warrant when he was visiting family for the holidays in New York.
How did Mr. Johnson get from Atlanta to New York?
I'm not sure. I believe he drove.
I apologize.
Say that again,
He
Mr.
drove me in a Astra.
Okay.
And so the jail, I understand their reasons. He's not on any pain medication, but he fell in the jail recently. So that has been an issue that he's been struggling with, is just the pain management. If he could be out, he could have access to the medications that he was normally prescribed when he was in Atlanta. Prior to his arrest, he was living off of Piedmont Road. He doesn't work because he's on disability, but he was before working in the music industry. He did 3 years of college at Clark Atlanta as an audio visual engineer. He's got adult children at this point. I believe he has 5 kids.
Morehouse right now.
And so in looking at his history, I believe the last felony that I had was a 2005 aggravated assault. I don't believe he's on any active probations. There is a complaining witness in this case. My client does not know her whereabouts. I understand that the state might have some concerns if he were released about that. He doesn't know where she lives, and so I don't believe that he would not have an issue with the stay away from her. Any family members related to this case. The car in this case belonged to complaining witness's sister. We would ask that Mr. Johnson be released on bond while we try to work on these charges. There's a lot on my end that I need to subpoena to build our case up. I was given a preliminary discovery packet from the state, but I spoke with my client. At this point, he could afford $1,000 bond. So what we'd be requesting is a $10,000 bond. He would consent to an ankle monitor, 24-hour curfew, with the exception of medical appointments, should he be released.
All right. Ms. Beza, well, before I hear from you, Ms. Beza, Ms. Crawford, if Ms. Beza, you've got this, you can cover it. I'm interested in hearing about Mr. Johnson's criminal history. As someone mentioned, a prior aggravated assault, and so I want to make sure I understand the full picture.
There's one thing I did want to mention about that aggravated assault, and it goes to your question and also the Iola factor of risk of committing felonies pending trial. He did plead guilty on July 18th, 2005 in DeKalb County to aggravated assault and possession of a firearm, was sentenced to 5 years confinement, 10 years probation. While he was on probation, so while he was out, he then got his probation revoked, and on his GCIC, it says he was revoked for reoffending. So while he was on probation, he reoffended. So he is a great risk of reoffending if he is to be granted bond. In addition, while there was a warrant out for his arrest, on this case, he reoffended in New York and then had to be extradited here back to Georgia. So
tell me what the New York, as you understand it, what was the New York situation? I was under the impression that he simply got arrested in New York on the warrant from here.
Yes, sir.
Oh, I wasn't asking you. It may be that Ms. Patel doesn't want you to talk about that, Mr. Johnson. Ms. Beza, do you have any? I'll ask Ms. Patel in a minute, but Ms. Beza, do you have any information about the New York situation?
No, sir.
I do not have any further information about the New York situation. I'm trying to look at
Stop. Only one at a time. I was asking Ms. Beza. So you sit tight, Mr. Johnson. Okay.
I can barely hear you guys. I apologize.
All right, we'll speak up. Ms. Beza.
It may have just been that he was arrested on the warrant, but he is a risk of reoffending as shown from cycle 11.
I'm sorry. Could you speak up? The volume is at its maximum, but we can't really hear you that well.
Yeah, that's why I was talking.
Hey, we're doing our best. We'll yell a little bit.
Yeah, I'll yell. It may have been that he was just rearrested, but as shown on cycle 11, while he was on probation for DeKalb County case, he did reoffend for what they say was a fingerprintable offense. So I do believe that he is a risk of committing felonies pending trial. And I believe that he is a risk of the state's position, that he is a risk of intimidating Ms. Funderburk. I'm pronouncing her name wrong. If he were to be released, Ms. Funderburk sustained a stab wound to her abdomen. I spoke with her yesterday, and she is vehemently against the defendant being granted bond. She is afraid. Yesterday, when I spoke with her, she told me that she spent 40 days in the hospital, 25 days here, and 25 days, I believe she said it was either South or North Carolina. I did tell Ms. Patel that I will be subpoenaing her hospital records and I will be turning them over to her. She sustained an injury to her liver where she had to get a drain installed from this stab wound. She is currently still in pain. With that, that makes her very afraid of the defendant, and the defendant and Ms. Funderburk used to be engaged. Therefore, he will know how to find her, and he is at a grave risk of intimidating her if he were to be released. Ms. Funderburk, I believe, was on this call, but I think the victim service advocate gave her the YouTube link. She does not want to make a statement at this time, but she does want the court to know that she is against bond.
Okay. And tell me what the situation was with the car. I understand the stabbing, but it's a peculiar combination of charges. The allegation is Mr. Johnson stabbed Ms. Funderburk. Then I guess Ms. Funderburk's sister, Ms. Gladden, her car was taken.
Yes.
I didn't get the sense Mr. Johnson did lots of driving. What's your understanding of what the car situation is?
Mr. Johnson, do not speak.
He's on mute anyway, because there was so much background noise there. We'll unmute him when it's time.
Mr. Johnson drove the sister's car away from the scene. It's a Kia Sorrento, South Carolina tag, an unknown plate. So per the police report, page 2 of 4, he was seen in Ms. Funderburk's sister's vehicle.
Got it. So the allegations are on December 2nd of last year, he stabs Ms. Funderburk and then leaves that location by taking Ms. Funderburk's car.
That is correct.
Or her sister's car. Got it.
His
Okay.
sister.
Yeah. And tell me why, Ms. Beza, you think that ankle monitor and basically house arrest, where Mr. Johnson is leaving Ralph Dexter's home only to go to the doctor or to come to court. If those are the only, he's not going to work. So we don't need to worry about, well, he's going to work and this and that. If he's staying at Mr. Dexter's place 24/7, except for court and a doctor, and we're able to monitor that with the ankle monitor, why does that not address your concerns? And I understand your concerns. I'm not saying I just wondering why that approach wouldn't cover it.
Because he still has the risk of intimidating Ms. Funderburk. One thing about this case is, per Ms. Funderburk, the reason why they were arguing is over money that the defendant thinks Ms. Funderburk owes him. Prior to him stabbing her, he threatened to cut off her fingers if she didn't pay him back. I believe it's the state's position, he would still want this money. It's the state's position that he would still reach out to her for this money that he believes he owes her. So it gives him the motivation to intimidate her.
So do you have any evidence? Mr. Johnson's been in custody for a while now. And often what gets presented at a bond hearing that can be very persuasive is, here's a jail call and let's listen to it. And it's Mr. Johnson talking to Ms. Funderburk saying, I'm going to get you. That pretty much closes the issue and someone stays where they are. Do you have any evidence that Mr. Johnson has in fact engaged in any effort, direct or indirect, to contact Ms. Funderburk, either to say, I'm sorry, or, hey, you still owe me that money and you still have 10 fingers?
No, I do not, Your Honor.
All right. Ms. Patel, anything you want to say in response to the state's argument?
Yes, Your Honor. I'll try to be as brief as possible. With regards to the reoffending while on probation, the arrest was for a marijuana misdemeanor. And since— Meaning in New York, the arrest was? There is no, I reviewed the extradition paperwork. There does not appear to be any New York charge. We ran a GCIC. Obviously, it wouldn't show any NCIC stuff, but I was provided an NCIC by the state that did not reflect a New York City charge. There was a misdemeanor marijuana in Texas. With regards to, I did not try to get into the facts of the case, but I will just, for Your Honor's purposes, there's no dispute that they got into an argument about money that was missing. My client had about $20,000 in his checking account that was from disability. Next day, that money's gone. The only person that had his debit card was Ms. Funderburk. So they got into an argument. We are not contesting that part. My client is not able-bodied. There was an altercation. He has injuries himself. He's not— Meaning, let me make sure I follow that piece. Meaning you contend that as a result of whatever happened on December 2nd, Mr. Johnson sustained injuries as well. You're not referring to the fact that he's got a spinal injury. No, what I'm saying is that this is someone who is handicapped, and the allegation is that he was this perpetrator of this violent act that all occurred within a vehicle, and that he doesn't have as much mobility to move as Ms. Funderburk does, let alone to exit a car freely. He sustained injuries. He didn't go to the hospital. We're not disputing that he did take her car. I asked my client about that. He said that he called the police to report that he had left the vehicle at a location. I am working to get those records as part of proving that the vehicle was recovered, is what my client has told me, because he checked the following day to make sure that it was gone. And so I understand the state's concern. My understanding is that Ms. Funderburk lives in South Carolina, that she's not a Georgia resident. It's possible she actually does live in Georgia, but with an ankle monitor, he would be confined to the city of Atlanta. He has no reason to leave. I told him he can't see his family in New York if he's out while the trial is pending. You mentioned there was a marijuana situation in Texas. Yes, I believe it was in 2001.
Oh, so 20 years ago.
I don't believe it was recent. I don't want to misspeak. I don't have it. It was 1994.
Even older.
Correct,
Okay.
correct.
So it wasn't that Mr. Johnson was in Texas last year and then New York and et cetera. Okay. All right. Mr. Johnson, can you please get someone there to unmute your system now? Thank you. We muted it because because of where you're seated, there's a lot of background noise, and it was hard to follow what other people were saying. How do you know Ralph Dexter?
He's been a friend of mine for over 20 years.
Okay. And does he know that you are offering up his home as a place where you can stay?
Yeah, he wouldn't have a problem with it. I stayed with him since I had broken my neck and all that. I just had they took my phone. I had no contact numbers for anyone. You know,
Okay.
No one, a lot of my family, no one even knows I'm incarcerated. So
when did you sustain your spinal cord injury?
2016, sir. I broke my neck, and then I have chronic spinal cord injury where my spinal cord is hanging on by a thread. I have body spasms. I can't even stand up. I've been, like I said, confined to, I was crippled for 2.5 years. I've just started to be able to try to get any physical mobility back with my upper body and lower body. So I was confined to a bed for 2.5 years.
You have adult children?
Yes, sir. My son is attending Morehouse. My daughter graduated from Virginia State. She's going to law school now. You know, my father was in the Marine Corps 25 years, first police officer in our town. I'm not a criminal. Like I said, I'm in a situation I just caught up.
All right, just focus on my questions.
Yes,
so
sir.
you have a son who is here in Atlanta?
Yes, sir. He's at Morehouse University.
Okay. But you also have family up in New York. Who's in New York?
Yes, sir. I have my cousin in New York, and I have a friend of mine that's in New York. I've been known for 35 years.
Okay.
My first cousin's in New York. And I also have the vehicle up there. Someone would bring it back, though. Because my cousin had drove it up there, so I can get him to drive it back.
Yeah, you won't be going to New York. Okay.
I have no problem with that.
All right. Thank you, Mr. Johnson. So I would like to get a little more information. Ms. Patel, if you are able to get, it can be an email, it can be a letter, whatever is easiest, something from Mr. Dexter indicating that Mr. Johnson is welcome to be there 24/7 because it would be house arrest with an ankle monitor. And then Ms. Beza, you may be able to answer this now. I want to understand if Ms. Funderburk lives anywhere near this address. I don't need you to give me Ms. Funderburk's address, but if Mr. Johnson were to be staying at Mr. Dexter's home, he would be on King Mountain Court, which is somewhere in Atlanta. And if that's particularly near Ms. Funderburk, that's not an address that's going to work. So if you could please confirm that Ms. Funderburk doesn't live anywhere near, and by that I mean 15 miles radius of that address on King Mountain Court. If you know that now, you can just tell me. If you need to get on Google Maps to figure out how far away it is, then you can confirm that later.
I know that now. She does not live close to that address.
Okay. That gives me some comfort. So I am inclined to set a bond that is within Mr. Johnson's financial reach. More importantly, it would include the ankle monitor and curfew provisions so that we address the risk of flight concern. I appreciate that Mr. Johnson may be less mobile than Ms. Patel or Ms. Beza or myself. He nonetheless managed to get up to New York after this alleged incident, and that's where he was arrested. So he's going to need to stay nearby so that we know he can make it to court. The only bases to leave Mr. Dexter's home would be to go for medical appointments or to come to court or meet with counsel. If something changes in Mr. Johnson's life and there is an important reason why he ought to be able to leave Mr. Dexter's home on a regular basis, we need to have a discussion about that, and I'd be willing to modify the bond, but it doesn't sound like at this point Mr. Johnson's working, so there wouldn't be a need to do that. And then obviously, there would be no contact, direct or indirect, with Ms. Funderburk or Ms. Gladden. Direct contact, Mr. Johnson, is pretty obvious. That means that you're calling her or writing her. But indirect contact would be you have your friend Ralph Dexter reach out to Ms. Funderburk. If anyone is contacting Ms. Funderburk on your behalf, you're going to go back to jail and you will stay in the county jail until the case is resolved. You can raise your hand if you understand that. You understand that? He raised his hand. Great. So that's a real important thing for you to keep in mind. But I'm not going to sign anything until we get feedback from Mr. Dexter that he appreciates what it means to be having Mr. Johnson with him, because it will be a long-term commitment and it's a full-time commitment.
Right.
So, Mr. Johnson, Ms. Patel is going to work on that. She will forward that information to Ms. Beza so that she gets it, and to Ms. Nelson so that I get it. And if I'm comfortable with what I get, then I will likely sign a bond that you can make. So it'll be about that dollar amount that's discussed, but it will be with those three important conditions: no contact, ankle monitor, and curfew. Ms. Beza, do you have other conditions that you would want to see on Mr. Johnson's bond?
No, the main one is no contact, and you covered that. Thank you, Your Honor.
You bet. Ms. Patel, anything else for Mr. Johnson?
No, Your Honor.
Okay. Mr. Johnson, do you have any questions about what we just discussed?
Yes, sir. Basically, like I said, it wouldn't be any problem with me staying with Ralph. Ralph's like my brother. He's not going to have any problem. I stayed with him while I was unable to get around. He took me back and forth to the doctor. I just don't have any way to contact him because they took my phone when I was in New York and took it to some other place. And I have no numbers. But he's not going to have a problem with staying with him.
I hear you, and we're just going to confirm that. Ms. Patel has ways of tracking people down, so we've got a name and an address. It may be as fundamental as she has an investigator roll out to that address, but either way, I need something from Ralph Dexter, not from you, making clear that he is all right with this proposal. And it sounds like that he will be, so that's what we're going to do. Thank you, Mr. Johnson.
That concludes my business, Your Honor. May I be excused?
Yes, ma'am, but expect to hear from either Ms. Nelson or Ms. Hall about what we're doing with trial calendars.
Oh, I'll stay on then. Thank you.
Okay, great. We should have one more, I think, Mr. Barnswell.
Yes, Your Honor. He's in 1 North.
All right, we'll see. There's someone right there. All right, let me get 1 North going. Good morning, Mr. Barnswell. Can you hear me?
Yes, Your Honor.
Great. I'm Judge McBurney. You are here today for your plea and arraignment. Ms. Patel is your lawyer. She's in the courtroom as well. You may be able to see her on the screen. And I'm not sure who the prosecutor is. This seems like another Ms. Beza case, but she thought she was done for the day. Ms. Hall, is this your case or is it Ms. Beza's?
This is my case, Your Honor.
Any reason why it's your case and not her? I'm happy with it being whomever, but I'm going to tell you, Ms. Nelson is going to pull her hair out trying to figure out why one family violence ag assault is in one place and another is in another place.
Miss ADA Hall and I were a little confused as well. The DV deputy stated that late yesterday stated that this is not DV because at the time of the incident, they were roommates, I believe, or
Yes.
essentially roommates, and they hadn't dated. So yes, I understand.
Okay. It's gonna make it hard to prove up family violence battery then, but
Right.
that's the problem for the state rather than for Mr. Barnswell. Okay, we've got the lawyers we need. Ms. Hall is the prosecutor, Mr. Barnswell. Ms. Patel is your lawyer. I'm the judge. And I'm gonna hear from Ms. Patel.
Thank you, Judge. We are waiving arraignment today. I did file a bond motion. I was previously speaking to Ms. Beza about the case, so I apologize to Ms. Hall that I hope that, Ms. Hall, you were informed that we're adjusting bond today.
Yes, Ms. Beza told me this morning. I did. Well, we're not in a position to, well, I haven't been able to get in contact with the victim with it just now becoming my case. I didn't know that I should have been on the case, and that's my fault. It's not your client's fault. But because we haven't been able to get in contact with the victim to talk about bond, I wanted to see if we could probably reset this so that we can have our opportunity to reach out to the victim.
So here's where we are with that. I'm going to be less available over the next few days. And that also is not Mr. Barnswell's problem, or shouldn't be. So what I'd like to do is at a minimum hear from Ms. Patel today and from you, Ms. Hall, but I will withhold ruling until you have a chance, Ms. Hall, either directly or through a victim witness advocate to connect with the alleged victim in this case, who would be Ms. Ford, to see Ms. Ford's perspective. And you can relay that in writing, an email to Ms. Patel and Ms. Nelson. I'll be able to get that. And then I will be able to make a decision as to whether bond makes sense and if there need to be some conditions that maybe we didn't sort out because we did not have input from Ms. Ford.
Yes, Your Honor.
So with that, Mr. Barnswell, I'm going to hear from your lawyer first. It may be that there's something that I need to get from you. It may be Ms. Patel has a question of you. If I ask her a question and it gets into some personal facts about you, she just doesn't know yet. But mostly it'll be Ms. Patel doing the talking on your behalf, okay? All right. When you're ready.
Thank you, Your Honor. Before you is Mr. DeMarco Barnswell. He is 32 years old. Prior to his arrest, he was working at Zesto's on Moreland Avenue in United. It's not the Little Five Points location.
That one is gone. It got hit by a tree or a car or something. Sadly, I mean, we're losing Zesto's. The best one turned into a cookout. And then that one. So where's this one? Where's United?
It used to be Confederate.
Okay. I know where that is.
Right.
Yeah.
And he
United
was also working at Planet Bombay as a dishwasher, and that's in Little Five Points. His employer very much wants him back, has been calling.
Which one, Zesto's or Planet Bombay?
Planet Bombay has been calling his mother daily to see if he's going to be released. There is a shortage of employment and these restaurants are desperate. So with that being said, he will have secure employment should he be released on bond. Essentially, my strategy and what I told Ms. Beza about this case is that I am asking for bond. He has a very stable situation at home. Long-term, I'd like to see my client get into BHTC. He's been diagnosed with bipolar, schizophrenia. He's autistic. He was in special education classes when he was a child. So for a while, his needs were being maintained. He has Grady that he checks in with regularly.
Grady Act or Grady as in Park Place?
Penn Park Place. And he also sees a psychiatrist and psychologist at Mercy Care. This case essentially arose because my client was off his medication. And the reason for that, I spoke to his mother and his sister. He has been fairly stable with his medication. Medication management hasn't been an issue. Without getting into the facts of the case, but why he stopped taking his medication is he and this complaining witness used to date. Ms. Ford and him used to date. they had a pretty terrible idea that even though they broke up, she needed a place to live. He could move in with him and his mother. He's lived at his mother's home for quite a long time. She moves in, she's in a separate bedroom. They are not getting along. The mother then opts to kick Miss Ford out because she had stayed more than 30 days. Police said she had to formally evict her. So the amount of tension in the house is terrible. These are, they don't want Miss Ford there. They're not getting along. My client, just out of frustration, he stopped taking his medication, and then the date of the incident has a couple beers, which when not on his medication is not a great idea. When I talked to his mother, she said he is the sweetest, best child when he's on his medication. She would be here today, but she has a lot of health conditions. She's got a degenerative disease as well as neuropathy. So she basically sees a doctor 3 times a week. She's at a doctor's appointment today. He's on his medication at the jail. He's on Depakote, Prozac, and Seroquel. That is pretty similar to what he was taking outside. There is an additional medication that he would need. The stable address that he's been living at is 916 Redford Drive Southeast, Atlanta, Georgia. I spoke with the mother to confirm Ms. Ford does not live there. Shortly after this incident, a few days after she moved out.
Was Mr. Barnswell taken into custody the day the incident is allegedly the 15th of February of this year? So he was arrested, leaving just Ms. Ford alone with Mr. Barnswell's mom, or he didn't get arrested?
He was not arrested. So he was not arrested on the date of the incident. He was arrested February 26th.
So between the incident and his arrest, Ms. Ford moved out? Correct. Okay.
And police were called a couple times. He stayed during the I guess in the first call, they just didn't really treat it seriously. Second call, he's there. He decides, the mother and they both decide he needs to leave. He needs to cool off because he is very angry. And we're not disputing the fact that they did get into an altercation and an argument. His property was destroyed and he reacted very poorly to that. With that being said, in speaking to the mother, who isn't the kind of parent who's going to say my child is faultless, she seems fairly objective. She said, this is just, these two cannot stop coming at each other because they were living within the same house and hated each other. And so I think that tension will be relieved. They don't know where she went. I reviewed the body camera and she talked about moving out of Atlanta. And I think that might, not the state, but out of the city. And I think that might be why the state might have some issues reaching her. Should my client, Your Honor, should my client be released, he would live with his mother at that address. He has a sister who's very involved in his life. He would maintain the employment. I explained to both of them that if this program happens, employment usually goes out the window for a little bit. But I think that, his mother believes if he's kept busy, he's good. And as long as he doesn't have a girlfriend, he's also good. And she doesn't really intend to give him a phone to avoid the finding of a girlfriend online. Right now, his bond is a split bond. It's $10,000 good on, I believe, I believe it's on the ag assault, and then there was a simple battery that he was on no bond. I could have that backwards. Essentially, we would be asking for.
It's no bond on the ag assault and a $10,000 good bond on the simple battery. That's when it was a complaint. So there's this third charge for which there's also no bond, but there is, I don't know why one would call that a split bond, because it's not you can't get out with that bond.
Right.
That's
exactly.
peculiar. Okay.
So what I would ask for is a $1,000 bond through pretrial services level 1 on the simple battery, which I think can be supervised. And then I unsecured judicial release for the aggravated assault. Or I'm sorry, unsecured judicial release doesn't, it's the reverse.
Yeah, I don't think you can have unsecured judicial release on aggravated
Right,
assault.
right.
So in terms of financial commitment, however I broke it out, you're saying $1,000 sheriff 10% program. And then there could be some additional dollar amounts, but they would be UJRs.
Correct.
Okay, got it. And some judges already evaluated that, it was Judge Manning, that bond was appropriate for the simple battery, but didn't set a bond for the aggravated assault. Okay, that is helpful. Ms. Hall, I'd love to hear from you. If you know anything about Mr. Barnswell's criminal history, that would be helpful. If you don't, I can also get that from Ms. Crawford.
Yes, Your Honor. So the defendant, he has 5 felony convictions. Well, that was what I was able to pull from his GCIC dating back to 2010. His last conviction was 2017. And all of the convictions involve some type of violence, some type of harassment, some type of family violence, terroristic threats, fighting the police. But it does look like also in looking through his GCIC, it also deals with a lot of mental or health type of charges as well. With health institutions or something. I'm not sure what that was, but it did go in the same with Ms. Patel saying that he needs help, and that's been an issue. So all of them are violent charges, Your Honor. The last one I got was the 2017 SC case, which was I don't know. I didn't write it down. I'm sorry. I wrote down the one before that. But as far as the bond for the state, Your Honor, essentially what I wanted to make sure with the victim is that she's no longer living at the home. I know Ms. Patel has confirmed that with the mom, but that's why I wanted to speak with her, because if he did get a bond with the type of charges that he's had, it doesn't seem like it doesn't seem to be a good idea for them all 3 to be in the same home at all. Right. Even with the mom trying to break up the altercation with the victim, where the defendant punched her in the face several times and then held a razor to her neck, he ended up punching his own mom, which we can all assume that he didn't intend to do that. Yeah. But that's where we're at with it, Your Honor. I know he does currently have a bond, but I just wanted to make sure that the victim is no longer there and she's somewhere else, because of course I wouldn't ask for him to stay away from his mom's house. Right.
And it sounds like mom is willing to have him back without Ms. Ford present, especially if, as a condition of his bond, which it would be, he is back on medication and meeting with folks at Grady and Mercy Care. What's the best way to confirm that, Ms. Hall? I mean, we heard it from Ms. Patel. Is that confirmation enough, or did you want an opportunity to speak with Mr. Barnswell's mother?
If you can just give me, I was going to say to Friday. I'm not used to having court on Fridays. If you can just give me till Monday, actually. That's my last day before my vacation. I will try to get in contact with the victim again. I only made one attempt, and that was yesterday. This morning. So if you can just give me until Monday. If I can't get in contact with the victim, then I'll reach out to the mom and verify with the mom. And then I'll send Ms. Nelson and Ms. Patel an email just saying that I confirmed that she's no longer there. That was my biggest concern.
Okay. Ms. Patel, are you able to help? And it may be that Ms. Hall has a way to contact your client's mom. Do you have good contact information for, what's Mr. Barnswell's mother's last name?
Barnswell.
Barnswell. Do you have contact information for Ms. Barnswell, Ms. Hall, or would it help if Ms. Patel got that for you?
I was gonna get it from Ms. Patel.
Great. Okay. I just want to make sure that happens. I'm fine with your request. I think that makes sense. I'm curious, Ms. Crawford, are any of Mr. Barnswell's cases open and active?
Ms. Crawford may be gone.
There is an active case, Your Honor, the 2017 obstruction. Just recently, the state decided not to move forward on revoking him, and so that probation warrant has been cleared out.
And there was a warrant in the obstruction case predicated on this matter?
Yes, Your Honor.
Okay. If the state decided that, how do you know this?
I looked into it and then I communicated with the attorney that represented him on the probation revocation. So they filed a document just stating that they were not going to move forward with the revocation.
Got it. Okay. All right. Mr. Barnswell, you've been listening to all this. Do you have any questions about what we've been talking about?
I mean, Your Honor, like, I'm willing to do anything to, get help, because I really need the help, man. I'm tired of coming in and out of jail for my anger. That's what I've been praying for every night, man. I'm working on changing my life, sir, and I got a baby that's due in October.
You have a baby that's coming?
Yes, sir. I have a child on the way. It's not with Miss Ford. It's with a different female.
Okay, that's probably a good thing that it's not with Miss Ford. Would you be ready to go back to work?
Yes, Your Honor.
Okay. How long had you worked at Planet Bombay?
I worked there for like 4 months until I got on with our First Step staff and temp service.
Okay. And how long had you worked at Zestos?
I started Zestos this year, as a matter of fact, this past January before my birthday.
What did you do at Zestos?
I was a cook. I've cooked. I cleaned up the kitchen and the grill, and I also washed dishes.
Okay. All right. Well, thank you, Mr. Barnswell. So I'm inclined to set a bond if we get confirmation that Ms. Ford is not at the residence anymore. I think Ms. Hall's instincts are right. And if we can confirm that, then I'm inclined to set a bond. Of course, Ms. Hall, just like with the other case where we had a bond hearing, although it's with Ms. Beza, if you learn something from Ms. Ford, should you contact her that you think we ought to be weighing, I'll certainly consider that in an email that you send to Ms. Patel and Ms. Nelson. If you learn from Ms. Ford that Mr. Barnswell has been sending anthrax to her address or something, then Mr. Barnswell needs to stay where he is. But if you don't reach her, or she simply says, I'd rather he not have a bond, but doesn't give you a reason for any more concern than you already have, you can share that as well. But my intention is, unless we learn something from Ms. Hall that is inconsistent with Ms. Ford moved out, then I'll set a bond. Mr. Barnswell, it will be a condition of your bond that you have no contact with Ms. Ford. You don't call her, you don't write her, you don't go to places where you think you might find her. You'll need to be taking all your medications. So when you get out, you'll get back to Grady, you'll get back to Mercy Care and re-up your prescriptions, and you've got to stay on your medications. If you go off them and pretrial services figures that out, or probation, because it sounds like you're on probation, then we're going to need to decide whether you should stay out on bond. Okay? Any questions?
No, Your Honor.
All right, Ms. Patel, anything else in Mr. Barnswell's case?
No, Your Honor.
Ms. Hall?
Nothing further, Your Honor.
Okay. Well, I think that is it. Thank you so much, jail, sheriff's team. Good work. For those of you who've been on the call who don't work for the sheriff, if you have any feedback about how it worked with the booths, you can let Ms. Nelson know, you can let me know, and then and I'm going to get the rank wrong, but I think it's Lieutenant Dooley. She has put her email address in there. She is one of the point persons for working this booth process. And just for the lawyers who are plugged in, the value of the booth process is that in theory, we ought to be able to see more people in a single day. They are limited to the number of people they can bring down to courtroom 3 in the jail. There was an incident recently when they brought too many people. So they're scaling back courtroom 3. But we will have for an entire day, 9 to 5, all of the booth number 1s in the jail. And there's one on every floor in both towers. So we can have more meaningful calendars for cases where remote participation makes sense. Technically, it works now. I can mute it and unmute it and all that. It works real smoothly. There's been staffing issues on the sheriff's side as they try to work through this. But if you have a perspective as to whether it worked well or didn't, feel free to share it as we figure out, do we want to try to make this permanent, or was it just unfortunately an experiment that didn't work out? All right, I'm going to drop the folks from the sheriff's office from the call, and we're going to have a quick conversation about trial calendars with everyone else who's still on the call.
And Your Honor, before I forget, did you have a chance to sign the bond order Ms. Hansberry provided to you?
I'm not remembering signing a bond order, so I better do it today. What was the bond order?
It was for Brian Brown. We did his revocation a couple weeks ago, and then of course a pretrial warrant for not reporting popped up the day after.
I've seen a lot of correspondence about that. So what needs to happen? That we just get, is there some warrant that needs to be lifted, or be pretrial rolled off the bond and we need to reinstate the bond?
And so the order just reflects the same pretrial bond that was put in place for him prior to.
Okay, got it. So there's a Neil Barry on the call. Is that someone from your office?
That name does not ring a bell. Ms. Wood, do you know of a Neil Barry?
No, but I believe that might be a jail officer.
Yeah.
See,
he was sitting
like
there most of the time with
Okay.
the
All right, he's gone. All right. So I don't want to keep you guys on a Friday. I just want to talk a little bit about what's going on with trials. And I will get an email out later today so you get it. But the bench has approved a schedule for in-person jury selection through the end of the year. The changes are Monday. This Monday is the last jury selection in Assembly Hall. Won't be there again. Judge Edwards has a case that's going out. I think Ms. Sully has it from your office. And I don't know who the prosecutor is, but it's a murder case.
Simone Hilton.
Oh, that's right, Ms. Hilton. It is Ms. Hilton. It's been interesting hearing Ms. Judge Edwards talk about it. It'll be her first trial. So good luck to the lawyers. But we, in August, we'll start picking juries in 1C and 1D. You don't need to memorize this. I'll push the calendar out to you in a minute, but just so you know, the first week in August, we're going to pick 2 juries. And when I say we, it's still consolidated calendars for most of August. That first week, 1 jury one day, we'll try out 1C, and then 1 jury the next day, 1D. That second week, for this same consolidated calendar, because there's a 2-week calendar for the first 2 weeks of August, and then a 2-week calendar for the 3rd and 4th week of August. That second week of August, we'll pick 2 juries a day, Monday and Tuesday. So there'll be a jury in 1C and a jury in 1D, Monday and Tuesday. Once a jury is picked, the trial goes to the judge's courtroom. So if it's one of our cases, we'll be down in 1C or 1D, we'll pick our jury, and then that next day, we'd be here in 8D for the trial. But that's starting to ramp it up. For the 3rd and 4th weeks of August, it'll be that same model. 4 juries a week being selected, still a consolidated calendar. We're going to be expanding these consolidated calendars so we can use all the juries that we hope to be able to pick. And so you'll get another email today that will show you 3 or 4 bond cases and a few more jail cases that I'm adding to the two-week calendars in August. I'm adding them by fiat. And so it is okay for you to say, we can't go forward on it. It's not okay for the state to say that, but it would be okay for the defense, in particular, Ms. Wood, to say, you know what, I'm just inheriting this from Mr. Franklin. But it is a chance to resolve cases, and in particular, bond cases. And we know the science here. Getting a bond case on a trial calendar can often resolve it. So before on the defense side, you say, oh, I'm not ready to try a case, COVID, this and that. Maybe it's a way to resolve the case. Our trial calendar cases have been amazing vehicles. We've only had like 4 trials, but we've had like 10 calendars. And the state null process, the defense pleads, and progress is made. So don't panic when you see these things. I picked the cases out. You didn't have input. Starting in the very last week of August, which is part August, part September, we are beginning judge-specific trial calendars. And the cycle is by seniority. So that first day, which is August 30th, Judges Glanville and Adams will be picking juries in 1C and 1D. And it's going to be their trial calendars. And so the lawyers in that courtroom, if they're allowed to have input, they get input. But it will be only Glanville cases and only Adams cases. It turns out, it makes me feel very old, that I am the 4th most senior judge who has criminal cases. I'm not the 4th most senior judge, but a bunch of them are either chief judge or in the family division. So we will have a jury trial calendar on August 31st. That will be our cases only. Ms. Wood, you're new to the process. Ms. Patel, you've never really gone through the process. You're just not new to working with me. But Ms. Nelson will pull together the calendar based on conversations she and I have. If there are cases you want on the calendar, you can tell her, hey, please put it on there. And we'll have a calendar published far in advance. And then we as a group will talk about, here's the calendar. What do you want to try? And you'll know going into that date on August 31, kind of the order in which we're going to do it. It will not necessarily be the order of the calendar. The calendar is typically published by age of indictment. But the bond cases are typically going to be older indictment age-wise than the jail cases. But we'll have a chance, and Mr. Rao will be in the conversation, and the 8 other special units will be in the conversation so that we can know what's going to go. But we're not going to waste that opportunity to pick a jury. So we'll have 3 or 4 cases that are warm and ready to go, but they won't all be Ms. Patel's cases. I won't expect that Ms. Patel's ready to go on 4 trials. So this will be a learning as we do it process. But then about every 2 weeks, because there are only 14 of us with criminal calendars, with criminal dockets, and I forgot to add this last part, beginning that week of August 30th, we're going to try to pick 8 juries a week. So there'll be 8 cycles going. And that means if you do the math with 14 judges, that every 2 weeks, because there's some days we have to take off if there's a grand jury being selected or Labor Day or this or that. And you'll see the calendar because I'll share it, but we will be able to have jury trials about every 2 weeks, as will every other judge. So that's a little simpler if you're assigned to this courtroom. It's a little messy if you're one of these specialized prosecutors, because you're going to need to figure out where your other judge or judges are. And it'll all be on the calendar that I'll share with you because it lists where everyone is. But you all should know that the expectation is we will not waste a jury because of the backlog we have. And it's a lowercase b backlog. Folks have been doing a great job resolving cases. We don't have a huge caseload, but we have a lot of people who've been in jail for more than a year because we haven't been able to try cases. And so if cases require a trial to resolve them, we ought to have a trial every 2 weeks between now and the end of the year. I do not intend to burn anyone out. And so it won't be Mr. Rao going again and again and again. We'll try to balance it so that if it is Rao and Patel 1 week, then maybe it's Beza and Wood the 2 weeks later. But we can't control everything. And so it may be that Patel goes back to back. And we'll try to limit the number of times that happens. But of course, more cases are going to be Patel than anyone else because you're taking more of Mr. Franklin's caseload. As long as we're moving cases, I'm kind of agnostic. I'd like to move the people who've been in jail longer. Right. But if we're moving cases, I'm going to be okay if the pushback is, hey, Ms. Hall, Ms. Patel had trials this week and 2 weeks later. So even though the oldest case remaining is a Patel Hall production, could we do a Wood or a conflict defender or a private attorney? The answer is, of course we can. We'll do that. We just need to make sure we're taking advantage of these jury opportunities while we have them. Any questions about that? I mean for it to be very collaborative. Once we've got our calendars, it's a little less collaborative that first part of August. I just want to make sure we have enough of our cases that we can try to move some of them. But I don't control that count. That's a consolidated calendar, and our cases will be ranked by the age of the case, not the seniority of the judge. And I'm not very senior. Just the senior judges are in the family division.
I have a question, Judge.
Yes, ma'am.
I was looking at the cases that I have in your court part, and most of them have trial dates already.
Oh, right. Great point.
November. Does your calendar trump that?
Those will go away. Ms. Nelson has been doing an amazing job of planning as best she can for the unknown. And so one of your cases, Ms. Beza, we may have said final plea and your offer is 25 to serve because it's a rape, and your sense is it is a bad, good case, meaning you could prove it real easily. And defendant, I'm not going to take 25 years. Who would? So we move it to a trial calendar. Ms. Nelson needs to park that somewhere. And so she parks it with a placeholder calendar. So if you go into Odyssey, you'll see, hey, November 8th, that's fascinating. Those dates are out the window. We cannot have a calendar on a day that is not ours in this rotation you're about to get. So those will all need to be replaced. Ms. Nelson has had a wonderful week off. And I hope she rested because she's going to have to play that super complicated three-dimensional chess game that she does in her office and figure out, well, there was that November 5th calendar. There isn't that anymore. But now we know we're picking a jury on November 7th. So maybe I can move all those cases there. So please don't rely on the dates you see in Odyssey as of this moment in time. Ms. Nelson can let you know when she's rebuilt all that stuff. But this PDF I'm going to send everyone, that's just a calendar that I found as a template in Excel. I had the task of coming up with the rotation. Where you see McBurney, that's where we'll be having trial dates. You just don't know what's going to be on those calendars yet because Ms. Nelson hasn't figured out how she's going to pull off of the placeholder calendar she built to put them on these because she didn't have those dates. And my guess is she was probably about a month apart. That was usually how historically we had criminal trial calendars about once a month. We'll be having them every 2 weeks. They'll just be smaller calendars because we'll know what we're going to try. So great question. Don't be troubled by dates in Odyssey that don't match up with the PDF. PDF controls until Ms. Nelson tells you, I have updated Odyssey, and there should now be a one-to-one correspondence with what you see in Odyssey matching dates that we've got for picking a jury in 1C or 1D.
And then, Your Honor, I had a question.
You're welcome. Good question.
Mr. Franklin, I believe he told me that he had 2 cases scheduled in August, Bonaventure Flores and Glenn Goolsby. And so are those still good to go? I wasn't sure if the latest setup changes that for him.
So yes, is the answer. I queried our folks in court admin who compile the consolidated calendars to find out what was already on there. And Bonaventura is on one, Goolsby's on another. Bonaventura is the oldest case on one of those calendars. So it would be first out. I don't remember which one it is, but we'll share all that. And this is secret. I will be adding to those. And so I tried not to have too many Franklin cases being added. It's a lot of private attorneys being added. And it's also less clear to me what Franklin means going forward.
Correct.
But he and I did have a conversation about him keeping, assuming his supervisor allows it, Bonaventura and Goolsby, and trying those in August. They got continued once already. They're not going to be continued again unless, if the defense asks for a continuance, it's harder for me to say no to that, but they weren't continued so much at his request. So those are on there. And with those consolidated calendars, again, I don't have as much control. And so we would try the oldest one first, wouldn't make anyone go back to back. I would just let my colleagues know, because I tried Bonventura the first week, even though Smith is number 4 on that calendar, I won't use a jury the following week because I'm giving my lawyers a break. And I would let everyone know I'm continuing Smith from that August calendar, because I have other things I need to do too. I can't do trials back to back to back, or the civil litigants start crying. So those are still on there. Those calendars aren't fixed yet, but those will not come off. And in the email you get today, you'll see what's being added beyond those, so that we have enough to make sure we do use, because Bonventura may plead. And if it pleads, let's get another McBurney case in there if we can.
And then my follow-up was, so I went from 1 murder to 8, 4 rapes to 11. I don't know if it's the best use of my time to try to read 8 murders at once. And I don't know if Your Honor has any particular cases for the murders or the CWACs that belong to Mr. Franklin that are burning in the back of your mind in terms of trying, so that I can at least start in advance to look at that. I believe Mr. Franklin told me that apart from Dexter Beard, which is a 2014 case,
The one that just came back to us.
which
Yeah.
I don't have anything on. I believe that Michael Tutman might have been his oldest. And so,
So it's a good question. There's nothing burning other than I ask Ms. Nelson from time to time, give me the 25 oldest jail cases and the 25 oldest bond cases. And then unsurprisingly, I start at number 1.
Right.
This is a 4-year-old case. Why is it still here? And we just figure it out. Well, there's an evaluation, or there's this, there's a new prosecutor, whatever it is. So my preference would be to work oldest on down. But to your point, you've got 11 rapes. It may be that you determine I could be ready on the one that's 3rd oldest sooner than I could on the one that's 1st oldest. And you talk with your counterpart in the DA's office and everyone agrees, let's get that one ready. Okay. I'm okay with that. What I would caution against is finding the 11th oldest and saying, you know what, that one just looks easier for me, so I'm going to start with that one. That wouldn't be my preference. It would be, let's work our way down, but there may be reasons why you might need to leapfrog 1 or 2 for efficiency, or this one is going to involve Spanish language interpreters, and that's just a whole other ball of wax. And let's make sure we're comfortable trying a case in 8D. I've tried 2 civil cases here, and logistically it's about the same in terms of public distancing and the technology, but it's still not a criminal case. And so maybe we want to get one under our belt before we do one with interpreters or 2 defendants, because those restrictions are gone. You can now do multiple defendant cases because you're trying them in your own courtroom. And so if Judge X is comfortable having 2 defendants, they'll do that. I know one of my priorities for our first McBurney only calendar is it's actually a 4 defendant case, but 2 are going to trial, but they're private attorneys. And they know it's coming because they want a bond. And I said, but I think we can try your case. Right. And so it's murder, and that will give you a week off, and we will focus on those guys. Probably not the first one I want to try in here because it's 2 defendants. Right. But we can fit them. We'll make it happen if we need to. So you have flexibility. If you're communicating with Ms. Nelson and the prosecutors about here's how I'm prioritizing, and you are all in alignment, I'm not going to disrupt that.
Okay. And then I had Mr. Oliver scheduled around September 16th for trial, and I just wanted to make sure that is
right. You
on track. You
all have provided feedback when Ms. Nelson shared with me that list, and I said, "What are we going to do with these?" And you and Mr. Franklin said, "I might be able to be ready then or there." We've maintained those dates in the sense that I remember them, but those were dates that were driven by the old model where we were picking juries once a week, only on Mondays in Assembly Hall in these 2-week consolidated calendars. So Oliver is movable, and I don't know that we'll have September 16th. That may be a week where we don't appear in the rotation. But I'll remember that by mid-September, you committed to be ready to go on Oliver. Because you have new cases that are not new, you may say, I could also be ready on this case, which is older than Oliver, and then we could do that. Again, I'm happy to take guidance from you and your counterpart from the state if there's a different case. I just want to make sure for each of our calendars, we've got a meaningful chunk of cases to try. If everything pleads or falls apart, so be it. That happened in the old days where we were going to pick a jury. But jurors are more scarce. And unlike some judges who would have a 4-month rolling calendar and they just pick a jury any day they wanted, we get one try every couple of weeks. And so we want it to be as meaningful as can be. Ms. Nelson?
Oh, I was just going to say, you still have a booth connected and live.
Didn't hear what she said.
A booth connected from the jail.
Yeah, I know. I've been slowly disconnecting the booths while talking. It's a cumbersome process.